dear students and young lawyers, Singh Ruprah Arts, Commerce and Law College once again brings you a very important information about the latest judgment of the Supreme Court, Gohar Mohammed versus UPSRTC, decided on 15 December 2020. Important amendments have been made in the Motor Vehicle Act with effect from 1st April 2022 to ensure implementation of the beneficial provision incorporated in the motor guidelines and all police stations of the country to ensure that no victim of a motor accident remain remediless. The judgment is written by Honorable Justice Shri J.K. Maheshwari with his usual flair for the poor and the sufferers. Justice J.K. Maheshwari has laid down guidelines to be mandatorily followed by the authorities. I will highlight on some of these guidelines. Firstly, it is the duty of SHO of the police station to take immediate step as per section 159 of the Motor Vehicles Act. Secondly, after registering the FIR, investigating officer shall submit the FAR, first accident report, within 48 hours to the claims tribunal. The IAR, interim accident report, and the DAR, detailed accident report, shall be filed before the claims tribunal within the time limit prescribed. Thirdly, the registering officer is duty bound to verify the RC, DL, fitness, permit, etc. and submit the report before the claims tribunal in coordination with the police officer. Investigation officer will inform the victim about the action taken and produce the witness in the court. Distribution memo attaching the police stations to the claim tribunals shall be issued by the Registrar General of the High Courts. Further, Chief Secretary, Director General of Police shall develop a specialized unit in every police station to ensure the compliances. On receiving the FAR, the claims tribunal shall register it as miscellaneous application. On filing the IAR and DAR by the investigating officer in connection with the said FAR, it shall be attached with the same miscellaneous application attached with IAR and DAR for carrying out the purpose of section 149 of the Motor Vehicle Amendment Act and the rules. A reasonable compensation shall be awarded by the claim tribunal by making fair balance between the order and the offer from the designated officer of the insurance company. All insurance companies are directed to issue appropriate directions to follow the mandate of section 149 of the Motor Vehicle Amendment Act and the amendment rules, in which Rule 24 and Rule 23 must be complied with. If the claimant files an application under section 164 or 166 of the Motor Vehicle Amendment Act, on receiving the information, the miscellaneous application registered under section 149 shall be sent to the claims tribunal where the application under section 164 or 166 is pending immediately by the claims tribunal. If the claimants take recourse under section 164 or 166 of Motor Vehicle Amendment Act, as the case may be, they are directed to join nodal officer or designated officer of the insurance company as respondents in the claim petition as proper party. Registrar General to sensitize all stakeholders. And lastly, for compliance of mandate of Rule 30 of the Motor Vehicle Amendment Rules 2022, it is directed that on disputing the liability by the insurance company, the claims tribunal shall record the evidence through local commissioner and the fee and expenses of such local commissioner shall be borne by the insurance company.